After that, since we have come, that means the petitioner has the capacity to engage a counsel.
Lordship, on earlier occasion and date, on Lordship, adjournment was taken and she was
that's
not given
okay.
in Lordship.
No,
For that, she approached me, Lordship.
that's okay, but
Lordship,
if she has the,
Lordship, I'll direct Lordship. In fact, Lordship, I am also doing a pro bono matter. Lordship, I'll direct her.
No, some expenses have been borne. It should have gone to another person.
Lordship,
Now, since a private counsel has been engaged by the petitioner.
that Lordship, that I understand, Lordship. Yeah, Lordship may direct. I will
Okay.
inform her.
you just say that as last one. It is noted that this writ petition was filed through a legal aid counsel, and thereafter a private counsel has been engaged. Full stop. From the volume of the writ petition, it appears that sufficient expenses has been made by the Guwahati High Court Legal Services Committee in the preparation filing of the writ petition, we deem it appropriate that the petitioner would deposit a cost of ₹1,000 before the Guwahati High Court Legal Services Committee within a month. List after 4 weeks on receipt of records.
Lordship, in the interim, Lordship,
You get bail 5,000. Within 10 days, you appear
Lordship,
before the Superintendent of Police border.
obliged, Lordship.
Item 3.
May I have Lordship? Last occasion, His Honorable pleased to direct to the respondent counsel to take instruction from the concerned department, Lordship.
Lordship, Mr. Pang has taken the instruction as per my knowledge, Lordship, it is perhaps available in the DCP border Kamrup Metro, Lordship. So, Lordship, for the time being, Lordship, pass it for the matter. I will clarify.
Mas obliged.
Item 4.
May please, your Lordship. May please, your Lordship. Last occasion, Lordship, my Lord, LCR was called for, and on that day, my Lord, said after receive the LCR, interim may be granted, my Lord. My Lord, in this case, my Lord, petitioner declared foreigner, post of 71, my Lord. The grandmother and grandfather of the petitioner,
Just a moment.
yes.
Which page is the opinion?
Opinion, my lord, page 68. This starts from 69. No, my lord, I'm outside, my lord.
Mr. Sharma,
Yes, Lord.
we are giving some protection to the petitioner.
Yes,
We are giving bail.
Yes.
Heard Mr. F. A. Hassan, the counsel for the petitioner. Also heard Mr. G. Sharma, and standing counsel for the FT matters representing respondent number 2 and 6. And Mr. A.I. Anil, and standing counsel for respondent number 3, and Mr. P. Sharma, and additional senior government advocate appearing for respondent number 5, and Ms. P. Devi Leonard, L. Devi Leonard, CGC appearing for respondent number 1. The opinion dated 21/5/2024 passed by the learned forest learned member of Forest Tribunal Borpeta 11th in FT case number. Which page is the opinion?
68 my lord.
No, 69.
Delivery
68.
69.
68. This petitioner filed an article 220, sorry, by which the petitioner was declared to be a foreigner of post 25/3/1971 is assailed in this writ petition. The records call for resident examined. It appears that the matter would require some consideration. Just accordingly, the court is inclined to issue notice returnable forthwith without requiring the petitioner to take fresh steps. Next paragraph. In the meanwhile, the petitioner shall appear before the Superintendent of Police Borpeta within 7 days from the date of the order and shall furnish bill bond of rupees 5,000 with all those conditions.
Mm-hmm.
10 days could be. Bill 5,000. With those conditions attached. On failure to appear before the said authority within the time allowed, the order of bail session recalled. And shall stand lapsed due to use of time.
Published one.
Item 5.
May I please? Lordship. Opinion at page 21.
You have done the corrections.
Yes, Lordship.
What was the correction in the cost title?
Okay, it was a border. Earlier, we have not mentioned border. Superintendent of Police border. We have already mentioned Superintendent of Police only on the last of it. Thereafter, we correct it and make border.
Yes, what is the best document you have to connect yourself to your projected parents?
Page 46. Lord.
46. No, not the voters list, any other document except the voters list.
We have only the voter list, Lordship. Before 71, Lordship, we annexed 1970 voter list. Thereafter, my father expired, Lordship. In the voter list of 1970, Lordship, my father's name, along with
One former prime minister of the country
Lordship.
was a voter from Guwahati. I have his voters list. Now what happens if I produce it somewhere? I know that house also, where he stayed. What happens if somebody produces a certified copy of that voter list? We all know
In this case, Lordship, we have to produce voter list before 71, Lordship.
No, that's okay.
We have 70.
I'm also suggesting the same thing. Somebody is now producing a voters list, a very famous personality from Guwahati. Now what happens thereafter? Now, if something like that happens to you, are you ready to feed 10 people? They will say that this is the voter list, so therefore he is my father.
Lordship, 1971 voter list, Lordship, my elder brother's name was also recorded, Liaquat Ali. And
In-
Liaquat Ali deposed in my favor before the tribunal, Lordship. And we have annexed that, Lordship, that may be in case 59, Lordship. Liaquat Ali, case 59.
Page
59, next are 8.
Did he prove any document to show his identity card?
Yes, sir. His identity card along with Lordship, his voter list also we have annexed page 56, Lordship. Voter list of Liaquat Ali.
No, voters list is not a proof of identity.
Voter identity card also there, Lordship, page 58. Page 15 also. He is also resident of that same village, Lordship, where the petitioner's father was resided earlier, Alobati.
Mhm. Hmm, 71 voters list was not that nice. 71 voters list. It will be. What is given? That's 61.
Gaurav was also examined as DW3 lordship in favor of the petitioner.
But there's something wrong, the documents are not matching.
DW2 is page 59 lordship.
59.
Yes, sir.
Where's your written statement?
Page 50 lordship, 50. That's the general option. Deferred bill. This one maybe deferred is. Deferred bill.
Mhm. Mr. Sharma, if you don't give training to your AGP,
Lordship.
this is the entire exercise would be a partial exercise.
Yes, lordship.
What we are doing is a wastage of our time.
Lordship, yesterday also Payam was talking with the commissioner, Lordship.
No, we don't know.
Lordship, It
Speaking,
will be
speaking will not,
immediately, Lordship.
talking and doing anything will not help. We are amused with the manner which things are proceeding. In fact, for both of us, we find it amusing. We are sorry for whatever is happening. Mr. A.T. Sarkar.
Otherwise, age difference is 9 years between fathers and daughter.
No, not even that. The AGP does not even read what is required to be read.
Yes.
It's a, to read it is a wastage of time. Hmm? Hmm. No, no point. It's- Look, the entire exercise is a partial exercise. We can only express our displeasure and do nothing about it. Ms. L. Devi Lanet CEC for respondent number 1. Mr. G. Sharma standing also for respondent number 2 and 6. Mr. A.I. Alif standing also for respondent number 3. And Mr. P. Sharma Lanet, additional senior government advocate appearing for respondent number 5. Yes. Opinion dated 21/6/23, page 21. Notice call for the records. Bill 5,000. Failure to take bill within 10 days. Order of bill shall be revoked. Okay.
Item 6.
Most of the cases deserve to be allowed at the motion stage. In the process, my brother is also expressing. I am also of the same view. All these cases which are piling up has become an instrument for the people to attack the judiciary. And everybody thinks that nobody is working. But if this is the process in which the active matters are there, why should we waste our time? It should be allowed here and there at the motion stage, admission stage. Allow it and send it. This backlog can be completed in a year, within a year. You better call your what you call some secretary in your department. Let him be present. You want us to pass the judicial order, you request him by your own to be here. If you want, we'll pass a judicial order, asking him his presence to be here. Get a video. The manner in which the proceedings are taken up before the tribunal. Tribunal has prompted the court on various occasions to comment that it is open for the government to take an appropriate decision as to whether they would impart training not only to the GP of the AGP conducting trial before the various foreigners tribunal, but also to the learned members of the foreigners tribunal. It seems that these observations of the court is not reaching the appropriate authority in the government. Accordingly, we direct that at least one representative from the Home Department of the state of the rank not below joint secretary be present in court in few of the proceedings so as to understand the gravity of understanding the necessity of imparting such training. Full stop. Next, the learned standing counsel for the FT matters shall transmit a downloaded copy of this order to the Principal Secretary to the Government of Assam, Home Department for doing the needful so that a representative of the department is present in court on some days in these proceedings. In the Arnold case. In the last case, we are passing that order. Yes, Mr. Mazumdar.
Make with the lordship. My lord, last occasion lordship was pleased to call for the records lordship.
Yes.
And in the records lordship, just in presence of my friend, I have gone there.
A copy of the order.
Yes. Let a copy of this order be provided to the. We have said downloaded copy.
Yes.
If you want, just tell the courtmaster, he'll provide it to you. We don't need a judicial order for that. You just request the courtmaster, he'll give it to you. Yes, please tell us.
Lordship, petitioner is paid for leave of the court for production of some documents, lordship, the connecting documents.
Yes.
And lordship, during the cross examination, lordship, it was reserved for further cross. And then subsequently, as per kindly peruse the order dated of the office to, order of the learned member for tribunal lordship 31/2024.
31.
301/2024. Because I could not get the certified copy lordship because I applied for that also.
Pending. Yes.
Cross was both for further cross lordship, and then on the next date lordship 29/2/2024. Kindly fill that first. With all respect, lordship.
Lordship, proceeding is going on, lordship. They want to adduce new documents,
You've seen the order.
lordship.
And apart from that, lordship, please. Last occasion, the order which was placed before the learned court below lordship, page 45 in the cross part, lordship, it was on the record. I have found the certified copy. I have a certified copy. But page 45 of the records of the learned members for a tribunal lordship. After submission of the record lordship, I have heard that down below in my original certified copy lordship that while lordship please to identify that it was recorded their lordship. where while certified copy, I am not blaming anybody, Lordship. The learned advocate was placed the certified copy, Lordship. Then people, I'll not blame anything, Lordship, but here on the down, Lordship, something is noted, Lordship. After date, that was not, I have a certified copy of that,
Where
Lordship.
is that? Which page?
I have original copy of that, Lordship, I am giving. I have a certified copy of that, Lordship. That's a demand type of- I'm not for any dispute, Lordship. He is a retired government for a stranger, Lordship. It was subsequent.
We should. Recording the reverse phase of the written statement.
Which he cannot touch, Lordship.
Evidence of that. Not necessarily. Not necessarily. So when this one is concerned, everything is there in this way. It is really cheap.
Where is the opinion? Opinion?
Not
Oh.
yet, Lordship. Actually, I came before this honorable court for producing some further documents regarding the school documents, Lordship, admission as well as the Jamabandi of his paternal property.
Case 97, Lordship, he SL disordered, Lordship, 11/9/2024.
We think that he will be entitled to opportunity. The reason is that rightly or wrongly, by an order, the tribunal says that the cross-examination is reserved. And on the next day, he passes an order that the further cross is not necessary.
Lordship.
So on that day, he passes an order that the cross-examination is reserved for further cross. It's general.
Is there any petition?
Praying for setting aside the order dated 5/10/24.
Also, Lordship, because I obtained the certified
11/9/24.
copy. In that day, Lordship, just now I collect the certified copy of that, or Lordship, I need to,
Which
Fine.
order?
510, Lordship. Order I have, Lordship, of that.
No, you're challenging only the 5/10 order.
The
11/9 order, Lordship.
Okay.
Page 97.
Lordship,
Page
Lordship, I have,
97, Lordship.
I have a copy of that,
Page
Lordship.
97.
97.
Yes, Lordship.
I have a copy, certified copy of that, Lordship, just now. I obtained the certified copy, Lordship, but
Once you catch the order dated 11/9. Now, what is the reason to challenge this order?
actually, Lordship, in that day also my Lordship, for hearing, further hearing, and as well as the calling of the,
Let us read page 97. Let us read page 97. We'll understand.
may I read the type copy, Lordship?
No, please take us to the petition first. What is the petition and what is the order?
Lordship,
What is the petition
I am
on which this order was passed? Then you read this order so we'll understand because it's not
Lordship,
very
petition
clear.
is page 90, Lordship,
9.
90, Lordship. Cooperative,
This is submitted when?
it was submitted on 30/7/2024.
37/24.
7/2024. But official endorsement in the right side, left side, Lordship, put up on 29/8/24 for orders on this petition. 20.
This is a petition under order 6, rule 17. Or
So
what?
it may not be, Lordship, because I come across, Lordship, because production of some documents, Lordship, which
This was
Under-
after submission of evidence.
Yes.
after cross.
After?
Cross partly. For further cross.
Hmm.
It may be, this petition may be, with all respect, Lordship, it may be order 8, rule 1, subclause 3, may be, Lordship. But actually, what is Lordship, with all respect, Lordship, and submitting, Lordship, actually, in all the FTKs, Lordship, normally the learned advocates, Lordships are not properly, I am not blaming anybody, Lordship, but the conduct and also the court, also the members of the Congress Tribunal also taking it to be.
But in this petition at page 90, you're not referred to any document.
Lordship,
So it is rightly rejected.
actually, Lordship, the documents that it was a, with all respect, Lordship, that mistake on, I admitted that, Lordship, because I cannot, because some lawyers,
It is not a mistake, it is not a petition at all. Now, you read page 97.
may I read, Lordship?
Yes.
The petitioner side is represented by the learned counsel, hired so and so, appearing for the petitioner proceeding has been heard at length on the petition so and so filed under so and so. That was no such provision was mentioned in my petition, Lordship. Though the learned members have observed that, Lordship.
Okay.
There is none of the none to represent the state. The grievance of the petitioner in nutshell is upon the receipt of the notice from this tribunal. She entered, Lordship. He is a male, Lordship. She entered appearance with her learned counsel and contested the case by filing her written statement, followed by his documents evidence on affidavit SDW1. In support of her Indian citizenship claim, the petitioner proceedee had relied upon as much as 24 numbers of documents exhibited herewith. With these set of documents, the petitioner proceedee has sought to get her claim adjudicated in her favor with a declaration from this tribunal that she is not a foreigner, Lordship. I am a male, Lordship.
These are clerical mistake, Lordship.
I am not typing
No,
it.
it's okay.
Lordship, please. Sorry,
It's
Lordship.
okay.
Mr.
but
Bozunga,
His and
if
her.
I read this petition, also read petition, we'll find 100 mistakes.
Lordship, sorry. Sorry, Lordship, with all respect.
He or she. will
Lordship,
proceed.
sorry, Lordship. It is further to be stated that in due course, the initial argument for and on behalf of the proceedee was heard on 21/3/2000 and the case was posted for further arguments, if any. It be mentioned that though the case was pending for the further argument on various dates, which is yet to be heard, it is relevant in this context, the mention that on 37/24, when the case was taken up, the petitioner proceedee had filed a petition number so and so, praying there to allow him to file his additional documents, Lordship.
This is page 90.
Page 90,
Page 90 petition.
sorry,
Yes,
But
Lord.
that was not,
Yes, Lordship.
that was put up on 29/8/2024.
Lordship.
Yes.
So that was.
Sorry, I have gone in original copy of the order, Lordship. Page 98, just now I read,
Oh, here.
Lordship,
No, second para, it is relevant in this context to mention
that,
that on 37/2024. Now you are taking us to page 90.
Lordship,
That was a petition filed on 29/8/2024 or before that? Or before that?
no,
That you put up. That you put up for this.
put up on 29/8/24, Lord.
For us. 29/8/2024 or before that? Petition. Before. Yes. So, yes, right.
Upon careful perusal, praying thereby allowing him to file his additional document.
Hmm.
Upon careful perusal of the petition, it is revealed therefrom that by his pleading made at para number 3 of the said petition, he has stated that the effect that is what he has stated in paragraph
Hmm.
3.
Wholly quoted, entirely quoted. Right.
While
Hearing.
hearing on the said petition, appearing for the petitioner has drawn my attention on the provision contained in Order 6, Rule 17.
Why? Why he has taken to order 6 rule 17?
Lordship,
Yes.
which is quoted below. Sorry, Lordship.
No, omit the quoting part.
Mm.
It is noteworthy.
Then come to next part.
It is noteworthy to mention that under the proviso part of Rule 17, it is candidly prescribed that no application for amendment shall be allowed after the trial has commenced. Here, not to speak about the commencement of the trial of the case, even initial argument in the case is also over and the case was pending for further argument, judgment lodged. In this connection, I shall consider the relevant to rely on the decision of this honorable court, Guwahati High Court, Division Bench decided so and so, Nilban so and so, wherein while considering the petition under Order 8, Rule 9 of CPC, for allowing the petition to file her additional written statement and for producing the additional documents. Here, not our case is not for additional
You have argued on it.
lordship.
Your counsel has argued on it.
Lordship.
Order 6, Rule 17. So, tribunal had to observe on it.
Right.
Your petition is filing of document.
Lordship. Lordship.
But your counsel argued on Order 6, Rule 17.
All respect, Lordship.
Then how the tribunal could be held to be wrong?
I am, Lordship, my
So far, this part.
Lordship. With all respect, Lordship, I have
Even additional written statement, that is also not relevant.
not relevant.
Your prayer was to file additional document.
Documents, Lordship.
Okay.
As per the statement made in petition number so and so, it is earlier. However, on consideration of the Lordship third paragraph I am coming. However, on consideration of the entire matters of the said honorable court has also observed that so and so, that by filing petition, the petitioner has made an attempt to file up on the lacuna which remained after the evidence of the petitioner was closed and the case was fixed for the argument. In this connection, I also gone through and perused the decision of the Honorable Apex Court so and so, held that the court undoubtedly would take into consideration the question of serious injury, injustice or irreparable loss, but nonetheless should bear in mind that the provision for amendment of pleading is not available as a matter of right. Lordship, or I may be allowed to file a fresh petition to produce the documents, Lordship, because
No, we are only exercising 226 power.
Lordship. But
You approach the tribunal properly.
Lordship, because somewhere, somehow, Lordship, the petitioner will be prejudiced, Lordship, because it is a question of citizenship, Lordship.
Oh.
He is a bona fide citizen, Lordship.
We are then saying nothing. We just say that on your prayer, you withdraw it to approach the tribunal with an appropriate petition.
Lordship. And the judgment part may be, Lordship, with all respect, till decision of that petition, Lordship. The
We move that
final
application
argument.
because you have to move that application. It will be the tribunal's jurisdiction.
Lordship, may I, with all respect, Lordship.
It will take hardly 15 minutes for Mr. Mozumdar to draft a proper petition.
Lordship,
before the-
Lordship, please, yes, Lordship, actually, with all respect, Lordship, sometimes Lordship, I normally, today I'm expressing Lordship by official Lordship. This time I am also not, but some of the judgment Lordship of the apex court, may I supply that for consideration or to assisting your Lordship? If
Yes, please. If you want to cite judgments, we are not stopping
Lordship,
you.
just one is 2022, 2022 live law SC 533 law. Fully the
Live law, we don't have, what is the citation?
Lordship, I have a copy of that, Lordship,
Okay.
I'm supplying for convenience of this honorable court. From next question, Lordship, I'll submit a list of details, Lordship, with all fairness. Sorry, Lordship, I could not submit it today. Assess it.
You see, Mr. Mazumdar,
Lordship,
these things may not come to your assistance.
Lordship,
The reason is very simple.
Lordship, I could not,
No,
Sorry.
Please try to understand the situation. Here is the case where by an order dated 8/8/2024, the case is fixed for hearing and orders on petition.
Lordship,
No, sorry, this, what do you call it? This order of 5/10/2024,
Lordship,
in this writ petition,
Lordship,
the order says that for further argument and the case is fixed next on 29/10. On
Lordship.
29/10,
cross
it
an argument,
says,
Lordship.
it says that Hmm. No, sorry, the impugn order.
Lordship, Lordship,
The last line says fixing on so and so for further hearing and also for judgment.
Lordship,
After that, on 5/10, the matter is adjourned. And here it says further argument.
Lordship,
Correct.
Lordship,
So once the case is fixed for judgment, then there is also an order authored by me
yes, Lordship,
saying that after the matter is reserved for judgment, then the court would have no jurisdiction to touch it.
but
Therefore, we can only do is that we can permit you to approach the tribunal and do the
Lordship,
needful, but we can't give you anything more than that.
Lordship, at hearing stage also, your Lordship, the Honorable Apex Court held that Lordship amendment can be allowed, Lordship. I'll cite this then. 2017 SCC 5822, Lordship. Yeah.
2000,
I am giving the copy, Lordship. Huh? Huh? I am supplying the copy, Lordship. It will need. 2017. One will go into. One more will. Yeah. Just I am supplying the paper. I need to copy to code again. Nana Supreme Court, yeah. Sorry, Lordship, I have just scattered Lordship because of in this judgment, Lordship paragraph, I am coming Lordship paragraph 20. 2021 Lordship. Sorry, Lordship. It is a judgment.
No, no, you are saying about which paragraph?
That is,
2021.
sorry, Lordship, it is in the sage judgment paragraph 20,
21.
that 21
So
below
if
21.
if you board a train,
Lordship, sorry,
if you board a train from
reservation,
Guwahati to go to Barpeta,
Lordship,
can you reach Barpeta directly?
no, Lordship,
No. In the middle, there will be many stations.
Lordship, Lordship.
Come to para 13.
The provision to order for Rule 17 prohibit entertainment of amendment application after commencement with the object and purpose that the once parties proceeded with the leading of evidence or new pleading be permitted to be introduced. The present case is where actually before the parties could lead evidence and amendment application has been filed, and for the order dated so and so, it is clear that the plaintiff's case is that the parties have lead evidence even on amendment pleadings and plaintiff's case is so and so. The defendant in no manner can be said to be of prejudice by the amendment since the plaintiff lead his evidence on amendment pleadings and also claimed by him. Well, Lordship, sorry, Lordship, I am trying to best myself, Lordship, because cross was on, Lordship. Suddenly the learned member, Lordship,
Close the cross. How
Lordship
you are prejudiced? You are benefited.
benefited, but
Cross
Lordship,
is by government pleader.
Lordship, please.
How you are?
Only two, I relied on with all fairness, I am submitting, Lordship.
You are benefited
Lordship,
because further cross is closed.
and also we are supposed to other.
If
two-
you, that is your argument.
No, Lordship, just Lordship on that, only two documents, that is my admission register of my school as well.
You cannot produce document in cross.
No, but
Cross is closed.
sorry, Lordship, with all fairness, Lordship, I may be what Lordship proposed. Lordship, at least the petitioner may not be prejudiced, so that I pray,
No,
Lordship.
no. You see, we were just testing Mr. Sharma when you put that question. He should have responded by saying that if the cross-examination is closed, it will be the state who is aggrieved party.
But he is not aggrieved.
But he is not aggrieved
Because
by closure of cross-examination. So even if it is closed, how does the petitioner suffer any prejudice? It doesn't.
Lordship, only for, with all respect, Lordship, for establishing the linkage.
No, no. You see, we can't put words which are not there in your petition.
Lordship, please.
So we can merely say that you withdraw this
We
and
will go
take
by
30.
page 90 only. And the order passed
Sorry,
at page 97.
Lordship.
We don't find any
I leave it to
infirmity.
your Lordship, with all respect, Lordship, but my prayer is that for that till consideration of that
We
petition.
can't
Lordship.
we don't have jurisdiction to put to fill up the gaps.
No, I am not on
We
that,
can't say
Lordship.
that your
What Lordship was asked me to submit the petition there or desire to, that till consideration of that petition, Lordship, the hearing may be, Lordship,
no. It is for the tribunal. You make a prayer, it will consider.
because there are some problems are there, Lordship, with all fairness, I am submitting, Lordship.
No, we are
This
permitting you to
petition are,
file an
it is-
application.
and also lawyer, our part also, why he is not expressing, Lordship, the only two line, Lordship, can solve the purpose.
No,
And
Mr. Mazumdar, certiorari jurisdiction is if it testing and validity and finality of an order, then court's duty is whether it is to be set aside or not to set aside,
Lordship,
right? We
Lordship,
cannot travel beyond that.
Lordship, I am
And you are challenging this order only. Page 97.
97 also subsequent order which I was supposed to file affidavit because I just got the order, Lordship, of
No,
that,
it's
Lordship.
okay, 510 is, doesn't matter.
510 order, I may be,
510 doesn't matter.
Lordship, please.
510 is only consequential to the earlier order.
Lordship. Some protection, Lordship, otherwise,
Actually. This we do that, do that, do that.
I'll file a fresh petition, Lordship.
তাতে গৈ কৰক ইয়াত নহ'ব তাতে টাইম গৈ কৰক withdraw কৰি withdraw কৰক
আর একটা কপি দিই। আর একটা কপি দিই।
Regarding certiorari jurisdiction, Lordship, Honorable Supreme Court has passed very recent judgment, Lordship, regarding the 2023 SCC online SC 996, Lordship. Para 50 onwards, Lordship, 50, 51, 52, relevant para. Lordship. Lordship. Para 50, Lordship. Yes, Lord.
Mr. Mazumdar,
Lordship, please.
we are asking you,
Lordship, please.
now there is two ways to go about it. Number one, you have made a submission on merit. Do we consider that? Or we just close the matter, giving liberty to move the tribunal?
Again, a fresh petition, Lordship.
We are just allowing you to withdraw it and file petition. It depends on you, how do you present? But we are not adding any word. And second is that we come back to the first one and deal with your submissions on merit.
Lordship. May I pray, Lordship? If I will file the petition, Lordship, liberty may be given. If anything is adverse, Lordship, should I approach?
No,
the
for that you don't need a liberty. It's a second
Because-
order which you are challenging.
Lordship,
For that you don't need a liberty.
That will be
And-
new cause of action,
Lordship.
if it is a cause of.
Lordship, whatever, Lordship, we want justice, Lordship, the petitioner may not be prejudiced. With all fairness, I am submitting. I'm
That
not on
you see,
any,
that we don't know.
Lordship.
What will be the effect out of
No,
we don't know.
Lordship, only just to produce the 3-4 documents, Lordship. Whatever the decision the learned tribunal may take, but I may be allowed to submit the documents, Lordship, by filing a fresh petition, Lordship.
Okay.
Because I am not on that, Lordship, saying anything, Lordship. Because I know.
Heard Mr. K. Mazumdar, learned counsel for the petitioner. Also heard Ms. L. Devi, learned CEC, appearing for respondent number 1. Ms. P. Barwa, learned standing counsel for respondent number 2. Mr. G. Sharma, learned standing counsel for the FT matters, representing respondent number 3 and 6. And Mr. P. Sharma, learned additional senior government advocate, appearing for respondent number 5. So there is no representation from respondent number 4. Next paragraph. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has challenged the order dated 11/9/2024, passed by the learned member, Foreigners Tribunal 6th, Silchar, in case number FT 6th within bracket capital D bracket close 1916/2023. Post up by the said order, petition number 341/2024 was rejected. Post up. With reference to paragraph 3 of the order dated 25/10/2024. The records of the tribunal, which was called for, has been perused. And it appears that
Judgment, Lordship, regarding that supervision.
just
Paragraph 50.
as per order dated 30 January 2024, the cross-examination of DW1 was partly recorded and further cross-examination was kept pending. Full stop. The records reveal that the cross-examination was inadvertently recorded at the back page of the written statement instead of recording it separately or in the back page of the evidence on affidavit filed by respondent number 1. Filed by the petitioner as DW1. Full stop. Accordingly, it appears that the mistake of the tribunal is subsequently recorded at the bottom of the cross-examination, clarifying that the cross is, inverted commas, cross is inadvertently recorded on the reverse page of W/S instead of EVI full stop. It's EVI full stop of DW full stop 1. SD eligible comma, 5/10/24, inverted commas closed. Full stop. Thereafter, by order dated 29/2/2024, the learned member, Foreigners Tribunal 6th, has recorded that further cross of OP number 1, sorry, first cross of the DW1, as of now, the same is not necessary. And the matter was fixed for argument on 7/3/2024. And they're fixing the matter on 7/3/2024 for argument. That correction, right? Last line. Full stop. Next para. Subsequently, in course of proceedings, the petitioner filed petition number 341/2024, and the matter was heard on 11/9/2024. And they said petition was rejected. And the matter was fixed on 5/10/2024 for hearing the further argument, if any, and also for judgment. Full stop. Thereafter, the matter came to be adjourned by order dated 5/10/2024. And as records were called for, by order dated 29/10/2024, the records of the tribunal were sent to this court. Next para. After some deliberations, the learned counsel for the petitioner seeks to withdraw this petition and to with liberty to approach the learned foreigners tribunal 6th, Silche Kachar, and to file an appropriate application in the manner the petitioner may be so advised. Full stop. Next para. The prayer is allowed. The matter is dismissed for withdrawal with liberty to the petitioner as prayed for.
May I pray, Lordship, dismiss may be disposed, Lordship, or close, Lordship.
Huh?
The word may be, Lordship, dismiss, may be, Lordship, with all fairness, Lordship.
Yes,
It may-
closed on withdrawal with liberty as prayed for. Okay, right.
Sorry, Lordship.
No, it's okay.
I
It's okay. That liberty you have.
actually, sorry, Lordship.
No, it's okay. Just good to say that.
Come to page 97.
Lordship,
Third para.
the grievance of the petitioner in
No, before that. That line.
there is none to represent the state, Lordship.
In the process, you are saving a lot of money. State must be
Hmm.
complemented.
Much obliged, Lordship.
Item 3 may be taken, Lordship. Buying it here.
Hmm,
Much obliged,
Item
Lordship.
3.
Item,
3. There was some instruction in item 3, my lord.
okay, is the council available? No. We'll take it up when he's here.
Yes.
After some time. Yes, item 7.
Lord, in this case, my lord, the petitioner was declared foreigner.
What is your explanation for coming after 2 years?
I have explained, my lord, because I was just communicated with the said order on being approached to the tribunal in the month of August. Thereafter, we have prepared all these things for collection of copies and approaching this court, and I have explained it before your lordship while filing, drafting this petition.
What is the explanation?
The question lordship will file. In paragraph 21, my lord.
It's not a good explanation. Land counsel for the petitioner. Yes, and they will and CCC appearing for respondent number 1. Ms. P. Barwal and it standing counsel for respondent number 2. Mr. G. Sharma and it standing counsel for 50 matters representing respondent number 3 and the 3, 8, and 9. And Mr. P. Sharma and an additional senior government advocate representing respondent numbers 5 and 6. There is no representation from respondent number 4. Next paragraph. There's the concerned tribunal is not a necessary party, comma, the name of respondent number 7 is struck off without altering the seriatim of the other respondent numbers 8 and 9. Next paragraph. Page 23. The opinion dated by filing this writ petition on Article 226 of the Constitution of India, comma, the petitioner has received the opinion dated page 23, dated so and so, past tense so and so by so and so. By which the petitioner was declared to be a foreigner or post 25/3/1971 stream. That's true. Notice returnable in 4 weeks. Requisite extra copies of the writ petition be served on the learned CGC, State and Departmental Council within 2 days. Let the relevant records be controlled by the concerned tribunal. The petition shall appear before the which SP?
SP Bojali, my lord, now. Earlier it was Borpeta,
Now it is Bajali.
now what?
Okay, the petitioner shall appear within 10 days before the Superintendent of Police within bracket border, brackets for Bajali, and furnish bail bond of rupees 5,000. Same conditions, huh? It is made clear that if the petitioner does not appear within before the said authority within the time allowed, the order of bail shall stand lapsed by effects of time.
Can it be within 15 days, my lord?
Huh?
Within 15 days?
15 days by
Because there are some very poor persons, so arrange something. So it may took some time in communication of this order here and there.
okay,
Obliged.
15 days.
Deeply.
Item 8.
May I please, your lord? My lord, in this case, my lord, petitioner is a female, my lord. My lord, his father name, my lord, your lordship will find, my lord, chronologically I am coming, my lord. Page 18, my lord.
What is your explanation after coming for coming after a year? What is your explanation of coming after a year?
My lord, page 27, my lord. Page 14, paragraph 27, my lord.
Poor family. Which is the best document you have to connect to your
No, my lord,
projected parents?
so far document, there is no document, but my lord, her two sons of her elder brother appeared and deposed, my lord. My lord, her father's name appeared in the 1966 total list, then my lord, 1971, my lord. In the 1971, his elder brother's name appeared, my lord. Your lordship will find page 19, my lord. Nasiruddin, his father, my lord, her father, my lord, and Habibur Rahman, her elder brother, my lord. Then your lordship will find next, my lord, page 20.
See, it doesn't inspire in confidence because DW2 comes and says that he has a landed property inherited from the grandfather. See, if it's an inherited property of your grandfather and you say that he's your father, then you will get entitled to a part of the property, but you are disinherited. That means you are not a member of the family. Somebody coming and saying that you are a member of the family won't do.
My lord, in that concept, my lord, I have a submission, my lord. She was given married, my lord, prior to enrollment of her name in the voter list with her father, my lord. And she is also an illiterate, my lord. So, my lord, she did not have any document, my lord, to.
No,
link-
but your DW two comes and says that they have inherited property. Why were you designated?
No, they
You would
inherited
be
property-
designated only when you,
They inherited property from their father, my lord.
you are saying that your brother's son. So if the brother inherits property, why would not you inherit the property?
Under the Muslim law of inheritance, whether daughter is entitled or not entitled.
Entitled, my lord.
Then
But some, normally, my lord, daughter relinquish their, normally, my lord, that happens.
no, we don't know.
Relinquish their share in favor of their father, my lord. Normally, my lord, that.
No, you see, you expect us to know the law, not what happens. So now, if you are saying that you are the member of the family, but if you are out, you're not a member of the family. If somebody comes and says that he's my son, he's my daughter, we'll not make it that way.
But my lord, if the deposition of DW2 and 3 are, my lord, taken into consideration, my lord, I think, my lord, very consistent, my lord. Maybe, my lord, but
What is the name of your brother?
Habibur Rahman, my lord. Page, my lord, 19, 20, 19 and 20.
Mr. A.H.M.R. Chaudhary, the counsel for the petitioner. Also, Mr. L. Devi, learned CEC for respondent number 1. Mr. G. Sharma, learned standing counsel for the FT matters representing respondent number 2 and 4. And Mr. P. Sharma, learned additional senior government advocate appearing for respondent number 3. And Mr. H. Cooley, learned counsel appearing on behalf of Mr. A.I. Ali, standing counsel for respondent number 5. So there is no representation from respondent number 6. Next paragraph. Same order, only the opinion will change. Which page is the opinion?
Opinion, my lord. Starts from
Page 75.
page
Opinion.
75, my lord.
Opinion dated 7/9/2023. Passed by so. Same thing. Bail to the satisfaction of
Forfeit, my lord.
Superintendent of Police, Border, Borpeta. 10 days time to take bail. During which the order bail shall stand cancelled.
Deeply obliged.
Time being item 3.
This is suppose probably I was supposed to get the instruction whether records are available in DCP border Guwahati or not, because the reference is initiated by the DCP Guwahati, but trial was there in the Nalbari. So records are here, Malad.
Here,
She can appear here.
But, can you produce the record?
My lord, then I'll have 1 week, my lord.
Because he's challenging the ex parte decision
Yes,
of 2003.
yes. Record of reference is there, my lord. Court record, my lord. Record of reference is there. Before.
Watch out,
Yes,
the other records are not there.
yes. The police record is there. Other record will be there in the my lord, tribunal.
Nolbari one lordship.
So that's what you were projecting. Why did not appear? It's an ex parte, whether you received notice or not. What did you say?
The lordship, I have received the notice lordship, but concerning the lordship, since lordship 2003 lordship, so there are lots of trouble lordship. So I have explained in my delay petition also.
No, not for delay. We are asking that in 2003, when
So,
notice was, whether notice was served or not, what is your,
lordship, I have submitted a written statement before the tribunal lordship in the year of 2003 lordship. So some documents, my husband documents I have produced before this tribunal lordship. So as a layman lordship, no idea in this regard lordship. So the petitioner.
but if you submitted the written statement, then what is the fault of the tribunal in proceeding ex parte if you don't?
And the subsequent lordship, the petitioner did not appear as because there are lots of trouble since 2003 to 2020 lordship. So on that basis, lordship, the petitioner did not appear lordship, and the expert will be asked against me lordship. So I have sent my additional affidavit lordship. There are lots of trouble lordship. Each and every document I have appended lordship. So I have filed an additional affidavit on 25/1/10/2024 lordship. So here lordship, I have appended all documents lordship. And in the read petition lordship, my
Last, make your statements when you pen it down, make it readable, understandable.
and lordship,
You use certain words which we don't know. And cannot place it with the paragraph.
so para number 26 lordship, initially I stated in regarding lordship, delay condemnation lordship, 20 years lordship, and subsequently honorable court is stated in regarding this.
No, you see, you write something, when we read the paragraph, we don't understand the context in which those words are used. It leads us to a lot of difficulty.
Lordship, kindly see my affidavit,
It
lordship.
questions our ability to understand English. The
Lordship,
difficulty lies there.
lordship, with due respect lordship, so I have stated my affidavit, additional affidavit lordship, and I have submitted lordship.
To read certain English, if we don't understand, it doubts our ability to understand English.
Lordship, with due respect lordship, in affidavit lordship, page number 75 lordship, start lordship. Para number 2 lordship, I stated lordship. Start from page number 75 lordship, kindly see lordship.
You see your explanation given even in this additional affidavit.
Yes, lordship. So part of the delay lordship. So I have appended lordship that documents also lordship. The para number 1 lordship, I stated lordship. May I read lordship?
You see, in this Kaun Banega Crorepati, we have phone a friend. Now you have so many friends sitting behind you. You identify one of them and let them read this explanation and say that he or she is satisfied. Except for your chamber colleagues, identify any friend behind you. Phone a friend and tell them if they are satisfied. We'll accept the explanation. You are suffering from eye problem from 2011 to 15. I am suffering from eye problem since my school days. I am wearing spectacles.
So lordship, the petitioner husband is a auto driver lordship. Made an
That's okay, but
accident-
you.
made an accident lordship in the year of 2005 lordship. And
Opinion is of 2003.
and
In
2003
2005, you suffered an accident.
lordship, I have stated in the para number 12 lordship.
Many things would have happened. A lot of water flows under the Brahmaputra River bridge.
Lordship, one aspect is a lordship, the petitioner father is a railway employee lordship. And he was.
You see, we remember even last time we made a statement. You see, you say that in 2003, your husband
He met an
has
accident.
suffered with an accident. Now, we just wanted to know on the last occasion that if husband suffered an accident, whether you took steps to contest a motor accident claims tribunal case.
Lordship, the first.
There you
party-
went silent.
So lordship, I have stated lordship in the para number 4 lordship. So the first party insurance was not there lordship. So that's why lordship, when the collide with the divide lordship. So thereafter lordship did not file any kind of the MSC claims lordship before the tribunal lordship. So this is the reason lordship. The first party insurance was not covered lordship. I have seen para number 4 lordship, page 77 in my additional affidavit lordship. The professional auto driver in the jurisdiction of the Maligaon Sanction. Unfortunately, the petitioner husband made an accident on 25/2023 while her husband was coming from Pandu towards Maligaon, Guwahati, and had collided with the one divider nearby the main road of the Maligaon area. And the result, the petitioner husband was grievously injured in the different parts of the body. Thereafter, the petitioner husband brought to the central hospital, Maligaon, lordship, for the better treatment. While the accident was made, the first party insurance was failed. Therefore, the petitioner husband did not any kind of motor accident claim before the any land tribunal lordship. This para number 4 lordship. I have appended the type copy of the certified registration certificate lordship. I invite auto number lordship AS01KC 1299 lordship, annexer 1 lordship. This is the registration certificate of the auto lordship. My husband auto lordship. And lordship, next day lordship. Para number 7, I have stated page 78 lordship. Is a money receipt of the laboratory test report lordship. My father was under treatment lordship. Is a my eye trouble lordship. My father lordship. So during that I have spent a lots of time lordship. And even though I have fully engaged that particular trouble lordship, I annexer 2 and 3 lordship I have appended lordship. And I have stated para number 8 lordship, page number 79, is a discharge summary of the petitioner husband lordship. Yeah, my husband name is Niranjan Nondi lordship. In the ICU, the suffered the breathing difficulties with fever lordship, and their documents have appended as an annexer 4 lordship. The type copy of the discharge summary, the petitioner husband by patient number, ID number, so and so lordship. So annexer 4 lordship in my additional affidavit. And lordship, another discharge certificate lordship, I appended 5 lordship, page number 80 lordship. The petitioner husband lordship, and this one also documents lordship regarding lordship. Some trouble lordship regarding the medical treatment lordship, and due to the accident lordship. And lordship, one aspect is lordship, whatever lordship the border SP of the Nalbari lordship, the impose the statute of this notice lordship as a deporter. Where is my residence is absolutely Nalbari, Guwahati lordship. My father is a railway employee. And annexer 1 in my read petition lordship, which is clear defined lordship is a railway certificate lordship, the pension order lordship. Page number 26, which is clear defined. And my father date of birth is 1941, before independent lordship.
No, merit will come later. First is that your non-appearance before the tribunal led to an ex parte opinion of
Yes.
2003.
Yes, lordship, I have explained lordship. Each and every
2003, you are appearing in 24 after 11 years.
Yes, sir, I admit lordship. I admit.
21 years.
Yes, lordship. And para number 10 lordship in my affidavit lordship, additional affidavit, page number 80 lordship. Here also I'll define lordship.
Page number
Page number 80 lordship in my additional affidavit.
80.
Yes, lordship. In my additional affidavit lordship. So that with regard to the petitioner had been so far the different kind of trouble and anxiety like the financial distribution, hardship, husband, medical treatment, survival medical expenditure, daughters look after so and so, so and so. These are lots of trouble, Lordship. That despite the petitioner herself has been suffering high pressure disease since last more than 8 years till death. Therefore, the existence petitioner had forgotten in respect of their pending litigation with the which was being going on before the Tribunal Nalbari. The petitioner had somehow reliable input.
What is the meaning of this, Mr. Das?
Which one, Lordship?
Petitioner had copied somehow reliable impute.
Furnished, Lordship.
Huh?
Furnished. Jogan. It's like a opt-in, Lordship. Furnished.
No, we don't know. When you are reading English, we don't understand. That's why we say we are repeating it again.
So
At least speaking for the bench, I am speaking for myself now. I am doubting my ability to understand English.
so and Lordship,
And Mr. Das, in a repetition, why a petitioner is required to whisper? In a repetition, petitioner whispers. What is the meaning of whisper?
smoothly.
You don't know, Mr. Pine to hear it.
So, like technical defects on the other lot to be considered in this regard, Lordship. It's because my father is a railway employee, Lordship. As a documents, Lordship. So on that way, Lordship, is a genuine citizen of India, Lordship. I'll be ending.
So that's half of the interest is lost when we don't understand things. We think if I can speak the word in the equivalent English, I am not getting it right now. It's absolute bakwas. We lose interest then thereafter. If you don't understand, and if this is the reasons for giving us explanation of 21 years of delay.
So, Lordship, Lordship, I have appended the each and every documents. So, Lordship, on that basis, Lordship, after met an accident, my husband, Lordship, there was some lots of trouble, Lordship, and my father also some trouble in the eye difficulties, Lordship, and I admitted the hospital, and thereafter, Lordship,
No, you see, Mr. Payag is ready to give an undertaking. The state will take good care of you.
and as a
Once you are apprehended, Mr. Payag will take an undertaking. The state will take good care of you.
so existing petitioner is being a maid, Lordship, is a working the different
No, there's no
Survival
explanation at all.
two minor daughter, Lordship.
Explanation is absolutely not there.
So, Lordship, the litigant should not be suffered in this regard, Lordship. So I may allow to Lordship is because
So who in this room doesn't suffer anything? Which is the person, good person on the earth, on whom no misfortune has come?
so Lordship kindly
Tell me
consider,
name of
Lordship,
one good person.
Lordship kindly consider as because Lordship on the basis of the documents, Lordship, the relevant documents. Because my father is a railway employee, Lordship. I have appended the annexure 1, Lordship, in my read petition, Lordship. Page number 26, Lordship, kindly say, Lordship, page number 26. Page number 26, Lordship, and here, Lordship, my father, date of
You are
birth.
explaining 21 years of delay.
Lordship,
You appear before the tribunal, thereafter you don't appear. All these misfortunes have come later on.
in my so basically, Lordship, after made an accident, Lordship, my husband. So thereafter, Lordship, the lots of trouble arises, Lordship. So that's why, Lordship, and due to the hardship, financial hardship, and she was engaged the maid, Lordship, in the territory of the Maligaon, Lordship. So the somehow survived, Lordship. So on that way, Lordship, the lots of trouble and forget in regarding this litigation, Lordship. Even the Lordship, the person who is by board and board and Maligaon Lordship, and the notice from the Nalbari SP border Lordship. So on that basis, Lordship, and lots of trouble arises of the petitioner Lordship. And when he come to know in regarding this Lordship, the expertise reference judgment was
But
passed.
from the statement, Mr. Das, page 78, paragraph 6, it appears that it is the petitioner who had engaged a maid, not petitioner who served as a maid. Who had engaged, who had been engaged.
Yes, Mr. Pang.
The first difficulty is the delay in approaching before the Honorable Court, because it was not that the notice was not served. Notice was properly served. She appeared before the tribunal, filed WS, then she abandoned my lord. It's pure negligence. Why they are approaching before the Honorable Court now? That is due to my lord the NRC upgradation. Otherwise, they would not have my lord approached the Honorable Court. This is the only issue, my lord. After NRC, when NRC was upgraded, when the person is declared foreigner or there is case pending against him, his name will not be upgraded in the NRC. So when NRC rejected, these people are my lord now coming before this. This is the only reason of my lord this coming now before this. Otherwise, my lord, they would not have come. No, Lordship, what happened, Lordship? The legacy data of the petitioner father, Lordship, page number 30. There legacy data also available, Lordship, of the petitioner's father, page number 30, Lordship. Is 30. The original copy is page number 31, Lordship. So this is the NRC Lordship documents. The Badal Chandra De Lordship is my father Lordship. If the father is our Lordship, NRC is availability in this record Lordship. So she is my daughter Lordship. As a daughter, so how do you?
By the way, since you are out of track for some time, some years in fact, what would be the cost of an auto? Auto rickshaw, what would be the cost?
1 lakh.
1 lakh. 1 lakh, I don't think you'll get it. Is it perhaps okay, we take it 1 lakh.
In between 1 lakh.
Huh? We don't know, Mr. Pang will know more, you can find it out from internet. Price of an auto rickshaw.
So during this
Correct.
time, most probably 1 lakh to 1.
It's okay, we take it up, it's 1 lakh, you say 1 lakh, we accept it 1 lakh. Now, how poor would be a man who is having 1 lakh rupees?
So the finance Lordship, the down EMI is.
Oh, come to page 83. Come to page 83. Your husband has purchased a new auto rickshaw in in 2000, 28/8/2018, and there is no finance. Now you say that your husband is suffering from so many illnesses, suffering from eye problem, suffering from breathing problem, heart problem,
This one new lordship. The
after suffering a motor accident.
this one new lordship.
No, I understand, but you see your husband's condition is critical.
Previous years.
Is it not? Somebody told me, I don't remember it
Lordship.
exactly. I can't remember it well. But somebody told me in Bengali there is a saying, Joto dos Nanda Ghosh. So you make us read things and then
So lordship, we do
annex
respect
so
lordship.
many things.
So
And
nowadays-
you make it read us.
The
No explanation of
annex-
21. We'll be dismissing it, Mr. Yes, we don't find any merit. No, but Mr. Pang, we have not heard you completely. You were saying that you want it to be allowed.
My lord, your lordship was asking for the instruction, whether the records are available in DCP portal, Guwahati or not. The records are available, that must.
Okay. No, on merit, you want this to be allowed.
No, my lord, as I have already submitted, my lord, it's pure negligence on the part of the my lord.
Okay.
The concern with due respect, lordship. Lordship, with due respect, lordship.
Dictation of this matter, dictation of this matter, we are deferring it till we complete our motions because there's a single bench also.
Yes, lordship.
Passing of the orders, we are deferring it for some time.
Yes, lordship.
Let the motion matters be over.
Yes.
After some time. It will.
Must, lordship.
Item 9 for motion.
May I please, Lord?
Yes.
Contested matter, Lordship.
What is the explanation for 5 years delay?
My lord, case 27.
Was it
There are
18?
26, Lord.
6 years. Yes.
There are 26, Lord.
Para?
26,
Which page?
27.
We'll call for the records. Your prayer for bail will be considered on the next date. But we'll say that you will not be deported. For 5 years, this explanation is not sufficient. Third, Mr.
S.I. Talukdar.
S.I. Talukdar, learned counsel for the petitioner. For Union of India was there. Nobody is there. Also heard Mr. G. Sharma, learned standing counsel for the FT matters representing respondent number 2 and 4. And Mr. R. Talukdar, learned government advocate appearing for respondent number 3. And Ms. S.T. Khan, learned counsel appearing on behalf of Mr. Ms. P. Barwa, learned standing counsel for respondent number 3. 6. By filing this repetition in Article 226, opinion dated. Which page is the opinion?
79.
78.
9.
Between 79. Opinion dated 26/9/2018. Passed by so and so and so and so. Keeping the issue of delay and latches in appearing in filing this writ petition open, issue notice returnable on, give a date after 4 weeks. Last week, make it 13 December 2024. Requisite extra copies of the writ petition be served on the CGC, State and Departmental Council within 2 working days. Let the relevant records be called for. The prayer for bail shall be considered on receipt of the records of the tribunal. However, it is provided that in the petitioner shall the petitioner, apprehended, shall not be deported out of India without an order of the court. Next list on 13/12/2024. Bail will be considered on that day. You want your presence to be recorded?
No, my lord.
Item 10,
My lord, this is an ex parte order. Opinion page number 18, relevant portion, page number 19, para 2, my lord. The notice was not served on the petitioner, my lord. He came to know only when he was arrested, my lord. And he's residing in the same place.
You have produced the service report?
No, my lord, this order is there, my lord.
Okay, went to the village, came to use the village. So if he's last resided where he was there,
My lord.
that is sufficient service.
But my lord, he had no idea about it. He was not aware of this.
That would not be acceptable. We'll call for the records, we'll examine it, but
Person is detained.
will not be able to give you bail. You merely say that you'll not be deported.
No, my lord, he is in detention right now.
He's in detention, okay.
My lord.
Okay. But Mr. A.W. Aman, learned counsel for the petitioner. Also heard Ms. P. Barwal, and it's standing counsel for respondent number 2. Mr. G. Sharma, and it's standing counsel for respondent number 3 and 5. And Mr. R. Talukdar, and government advocate appearing for respondent number 4. So there's no representation from respondent number 1 and 6. Next para. By filing this writ petition, opinion dated. Which page is the opinion?
18, my lord, 1/8,
1/8.
3/4/21.
Page 18. Opinion dated 3/4/2021, passed. Ex parte opinion dated 3/4/2021, passed in so by so. By declaring the petitioner to be a foreigner of post 25/3/1971. Is sailed in this 91. Stop. Notice. Extra copies within 2 days. Call for the records. Prayer for bail shall be considered on receipt of the records of the tribunal. Next, in the meanwhile, the petitioner shall not be deported out of the country without order of the court. Next, the learned standing counsel for the FT matters shall transmit a downloaded copy of this order to the competent authority of the transit camp, Matia Kualpara. So this sort of 4 weeks on receipt of records of the tribunal.
Date may be fixed. My lord.
Date we are getting to now, we are in the last week. It will be very, you make a mention in the first
My
week
lord,
of
my lord,
January.
my lord. Grateful, my lord.
Item 11.
Okay. Pencil for you.
Petitioner is already taken in custody.
on 8/8/24.
Taken into custody.
Yes, Lordship.
Okay, same order, taken into custody, same order, last one. Which page is the opinion?
Opinion page 18, Lordship.
Page 18.
1/8.
Mr.
M. Ahmed.
M. Ahmed, learned counsel for the petitioner. Mr. J. Pang, learned standing counsel for respondent number 2 and 6. Mr. H. Cooley, learned counsel appearing on behalf of Mr. A. Ali, standing counsel for respondent number 3, and Mr. R. Talukdar, learned government advocate appearing for respondent number 5. Notice call for the records, extra copies within 2 days. Will not be deported. Bail shall be considered on receipt of the trial court records of the tribunal.
I also. I think
Pass a common order in
I.
along with IA. Give extra copies to the IA also.
Yes.
Passing a common order.
12.
It's a recent opinion. We are issuing notice. Give them protection. You're not arrested?
Not yet.
Okay. Your name?
W.A. Sheikh.
W.A. Sheikh. Okay. Make sure that your clerk gets your adequate payment for his services. Correct? You have a clerk?
Yes, madam.
Assure them that he has he's paid well.
He is, madam.
Because the name you said is not there in the writing.
He sometimes write it in the opposite way.
That we don't know. Because
I'll-
then
I'll
again,
talk- I'll talk
your
about it.
citizenship will be in doubt. If you have name of so and so, alias so and so, then your
I'll talk, madam.
Mr. Pang will definitely refer your case there. Be sure of your name, or or ask your clerk to be sure of your name.
My lord.
Mr. A.W. Sheikh for the petitioner.
Oh.
Mr. J. Pang, then it's standing counsel. Also heard Mr. J. Pang, standing counsel for respondent number 2 and 3. Mr. R. Talukdar, government advocate appearing for respondent number 4. And Mr. H. Cooley, counsel appearing on behalf of Mr. A.I. Ali, standing counsel for respondent number 5. There is no representation from respondent number 1 and 6. Which page is the opinion?
78.
Page
78.
78.
72, sorry.
72.
72 to 80.
Okay, 72. Opinion dated 27/8/2024, passed by so and so and so and so. Notice call for the records. Give bail to the satisfaction of Superintendent of Police, border. Which place?
Gwalpara.
Gwalpara. 10 days time to take bail.
Thirteen.
First rule is.
Okay, Lordship. Lordship, page 90 is the opinion, my lord.
What is the explanation for delay? 2 years delay,
My lord, page 24.
24.
The poor person. There are 22.
This paragraph projects you in a bad light. For your fees, you have to beg. It projects you in a bad light. You're doing nothing for the society.
Right.
Opinion of 22. At least tell us what does it, why does a poor man require a PAN card? Do you have any reason for a poor man to have a PAN card? Okay. Yeah. Mr. M. Ali, learned counsel for the petitioner. Mr. H. Kuri, learned counsel appearing on behalf of Mr. A. I. Ali, standing counsel for respondent number 2. Mr. J. Pang, learned standing counsel for respondent number 3, 6, and 7. And Mr. R. Talbot, learned government advocate appearing for respondent number 6. There's no representation from respondent number 1 and 4. Which is the opinion the page?
Page 90.
90.
90.
School headmaster came and deposed.
My lord. Deposed, my lord.
Page 90, opinion dated 2/6/2022, passed by so and so and so and so. Notice extra copies within 2 days. Call for the records. Appear before the Superintendent of Police border, Dhubri, within
Dhubri.
10 days and take bail of rupees 5,000 in all those conditions. Clear to appeal, bail sent and revoked.
Highly obliged.
10 days time to take bail.
Obliged.
Item 14.
May I please your lordship? My humble prayer is for withdrawal of the instant petition, lordship. There are many discrepancies in our drafting and also in translation, lordship. With a liberty.
Yeah,
of
your name?
highness, A. Hussain, lordship.
Miss
A. Hussain.
N.
A. Hussain.
A. Hussain. Okay.
With a liberty to file a fresh,
okay.
lordship.
At the outset, Ms. A. Hussain, learned counsel for the petitioner, submits that there are certain inadvertent mistakes in the petition, and therefore she craves leave to withdraw this petition and to approach the court again. Most of all the respondents are represented. The matter stands dismissed on withdrawal with liberty as prayed for.
Item 15,
Worship, and the youngest council, it is just leave the court due to his sudden illness of his wife.
Pardon me?
It
Did
is
you not get it? Please repeat again.
the youngest council, it is Your Honor, that suddenly leave the court due to his sudden illness of his wife, Your Honor. Matter may kindly fixed next week.
Okay. List. In the, all sides are represented, both sides are represented. List in the next week as prayed for by land council for the petitioner.
item 3 for dictation.
Mr. R.C. Das, land council for the petitioner. Also heard Mr. J. Pang, Leonard, standing counsel for the respondent number 2, 4, and 2, 4, 5, and 7. Oh, yeah, there. Before that, Ms. L. Devi, Leonard, CGC appearing for respondent number 1. Then Mr. Pang. Then Mr. R. Talundar, Leonard, government advocate appearing for respondent number 6. Next para. The special counsel for the NRC, government of Assam, is made respondent number 3, who is neither a necessary nor a consent party in this. Neither proper nor proper or necessary party in this writ petition. So accordingly, the name of respondent number 3 is struck off without altering the seriatim of the part of the respondents. Next para. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the ex parte opinion dated 12/12/2003, passed by the learned. Which page is the opinion?
Page Lordship, 68 Lordship.
58.
68.
68.
The type copy Lordship.
Passed by the learned member, illegal migrants within bracket determination, bracket close tribunal, Nalbari. In connection with Details you'll find it page 68. Case number so and so, arising out of police case number 1124 of 98. By which the reference that the take the name not from 68, huh? There's a typing error. Take it from page 71. It'll be police case number 4124 of 98. Answering the reference in the negative. In favor of the state and against the petitioner, namely Srimati Jaya Nandi, holding her to be a illegal migrant. Next paragraph. As the learned standing counsel for the FT matters has taken the plea of delay and latches on part of the petitioner to challenge the impugn opinion after (21 years), the issue of delay and latches in approaching the court is taken up first. Full stop. Next, by the learned counsel for the petitioner has referred to the statements made in this writ petition as well as in the additional affidavit filed on 20/10/2024 and has submitted that the petitioner has all the documents to show that she is the daughter of one Badal Chandra De, her projected father was a central government employee and had served the NF Railway till his retirement on 30/6/2001. However, on receipt of the notice of the proceedings, the petitioner had appeared before the illegal migrants within bracket determination bracket close tribunal common Albury within bracket IMDT for short, and filed her written statement However, later on she could not participate in the proceedings because of various reasons as assigned in the writ petition. Next, it is submitted that the writ petition was the written statement was submitted on 30 January 2003. Stop. Her husband, who was a professional auto rickshaw driver, had met with an accident in the year 2003. Who later on succumbed to his injuries. What is the name of your husband?
Niranjan,
Huh?
Nandi Lordship, Niranjan Nandi. Niranjan Nandi Lordship.
Niranjan Nandi.
Yes, Lordship.
But then you'll have to take a call. We'll have to ask the registry to lodge an FIR. You come to page 83. In 2018, your husband purchased a vehicle. If he's dead in 2003, I have great respect and I'm very fearful of ghosts. See, if there is a ghost, police should determine that.
2018, Lordship.
I don't know. There is your document, page 83. Name of the auto rickshaw
RC Lordship.
purchaser is Niranjan Nandi.
Yes, Lordship. Niranjan Nandi, my husband.
Then
Lordship.
your husband, you say in page 20, your husband died after the accident. So,
No.
Mr. Pang, extra work for you.
No, Lordship. Not died, Lordship. He's still alive.
You see, you have written here somewhere. Who met with an,
Well, like,
see page 20, who met with an accident in the year 2003 on sequel petitioner's husband was succumbed and grievous injury in disparity limb.
Grievous injury, Lordship.
Succumbed, what is the meaning of succumb? I don't know that much of English.
I'm
at
sorry
least
for that, Lordship. The grievous injury, Lordship.
No, whenever, that's why you said in the morning also, when you write something,
Lordship,
now we'll have to accept your lectures also.
Lordship, para number 4 in my additional affidavit.
I understand, but please understand our limitations. I can't flare up and speak something which is unparliamentary here. But when you write something, please explain it to us. So we'll have to not only read.
Lordship,
Now we'll have to take classes from you to understand what the meaning of succumb is.
Lordship, due respect, Lordship, initially the clerical mistake in the para number 525, Lordship. So subsequently, I find
No, what clerical mistake? If you don't read your petition, there will be hundreds of clerical mistakes.
I still in para number 4, Lordship.
You must spend some time reading it after you type it out.
Lordship, here, Lordship, the grievous injury, Lordship.
Please tell me, Mr. Das.
24, Lordship.
I make a lot of mistakes when the orders are passed. Correct. It happens after 3 levels of scrutiny. Now, to file an interrogatory application for correction of the order, do you like it? Do you love it?
Yes, I'm sorry for that. Lordship, here I
Don't you in your bar room, don't you go and criticize the judge, honorable judge who's made a mistake, and then file an interrogatory application?
Yes.
Please tell us, you write something in an affidavit that he succumbed, and then you say that your husband purchased, and I told you we are afraid of ghosts. At least I am. A ghost is purchasing a auto rickshaw driver, and then you say that it's a clerical mistake.
Lordship, para number 4 in my additional affidavit.
We don't know additional affidavits and all. For one word, do you have to read additional affidavit, the read petition here and there, and then find out what is the meaning of succumb?
Lordship, I'm
No,
sorry
no.
for that. Is a wrongly the clerical mistake. Sorry for that.
You see, we are time and again expressing. Whenever you are standing up, we are expressing the same thing. When we read your English, we doubt our ability to understand English.
I'm sorry for this.
Succumb, now we'll have to read meaning of succumb. I'll have to ask all the general
Sorry.
counsel to apprise me what is the meaning of word succumb.
Apologies, Lordship. So para number 4, Lordship, and that part I did not mention, Lordship.
Enough of lectures we have had, Mr. Das. School, we have been having teachers. College, we had teachers. In law college, we had teachers. Now, this is not a time where we should again go back to our alma mater and learn English.
I'm extremely sorry for that, Lordship.
Full stop. Full stop. Thereafter, the petitioner's family suffered financial hardship and could not take steps, which resulted in the ex parte opinion. Full stop. In the full stop. In the writ petition, there is no other explanation apart from what is mentioned herein before. Full stop. Thereafter, by filing an additional affidavit on 28/10/2024, the petitioner has set up has projected more reasons for the delay in approaching the court. In the explanation of delay, the petitioner has referred to solemnization of her marriage in the year 1988 and birth of two daughters in the year 1989 and 1991, which is absolutely unnecessary to explain the delay. After opinion was rendered in the year 2003, because the opinion was rendered in the year 2003, full stop. It is once again projected that the husband of the petitioner met with an accident on 25/2/2003 and he was taken to hospital for treatment. Full stop. It is also stated that no kind of motor accident claim was made by the made in respect of the said accident. Full stop. It is projected that somehow the petitioner could manage the family for all these years. And she is again referred, she is further referred to the eye treatment of her father from the year 2011 to 2015. Full stop. According to the case projected by the petitioner, her father was in government service and no explanation is given as to whether the in respect of expenditures for the father of the petitioner, no medical claim was made against the establishment from where he had superannuated. Full stop. in order to cover up the period from 2005 to 2016, it is only stated that the petitioner, the statement made in paragraph 6 of the petition is as follows, inverted commas, that with regards, page 78, that with regards the petitioner who had engaged as a maid surrounding area of Maligaon, as so and so, this para 6, what it, full stop. It is not understood as to whether the petitioner was working as a maid or she had engaged a maid. Full stop. Nonetheless, said explanation is not a good explanation to show the, to demonstrate the genuine reasons for delay in challenging the impugn opinion. Full stop. It is further projected that for 8 days from 27/2017 to 29/7/2017, my husband was in a hospital for about 8 days. Full stop. The said explanation also does not disclose any reasons why from 2003 to 2017, the opinion of the tribunal could not be challenged. Full stop. Thereafter, the husband of the petitioner served with, had suffered an eye disorder for 2 days from 24/9/2013 and 25/9/2019. And it's projected that the petitioner is also suffering from high pressure for the last 8 years. And thereafter, she went to the tribunal and obtained the certified copy of the order, and the present petition is filed. Next paragraph. Therefore, from the discussions as made above, we find that the petition has not been able to explain has not been able to satisfy the court with regard to the explanation tendered for challenging the impugned opinion of the tribunal after 21 years. Full stop. Even the explanation tendered does not cover the entire period of 21 years, but it's an intermittent misfortune which is projecting. Which is not sufficient for the court to exercise statutory jurisdiction under Article 226 of the Constitution of India to accept the challenge to the impugned opinion, which was rendered after due service of notice on the petitioner. Full stop. Next paragraph, the petitioner having failed to assail the impugned opinion within a reasonable time has allowed the order to attain finality. Next paragraph, accordingly, the delay having not been properly explained disentitles the petitioner to issuance of any writ in this matter. So accordingly, this writ petition stands dismissed at the motion stage without issuance of notice on the respondents.
Lordship, we do respect Lordship. So Honorable Supreme Court held on the judgment, Lordship. So the Siuraship case, Lordship, the latest judgment is a discretion power of the court, Lordship, concerning the delay, Lordship. The lordship consider in this regard, lordship, because lordship,
No, no.
the petitioner has been.
Had it been some explanation, we could have understood. Discretion must be exercised with
And,
within lawful parameters.
and lordship, another judgment, Tukaram Kana Joshi case is that after
After
30
completion,
years.
please don't argue. You could have placed those judgment earlier. We gave you opportunity earlier. Then again at 2 o'clock, we adjourned the matters that we'll dictate it later on. You could have given those judgments after dictation. Citation of judgment would not help you. You should have given it at an appropriate time.
Mass obligation.
This is not the first day you are appearing in court and don't know the court procedures.
I'm sorry.
You push us to a corner and then invite criticism. We then express ourselves in a manner which we don't want to. I'm a happy-go man. Want to come up in the morning with a smile, go out with a smile, without carrying any dead bodies in my mind when I go out. Don't make me change my character. It's not that I don't know how to be harsh. It's not that I don't know how to immediately react in a display of bad temperament. I'm not doing it because I'm not accustomed to it. My grooming up is that I should be resilient. Doesn't mean that I don't know these things. I've lived all my life here. I know how to react. Don't push me to a corner where we react. Because it's not only one case where we react and the ends the matter. I have another case to be attending in next. I don't want the other case to get disturbed because of unpleasant statements which I make in this matter. Correct? I've been here for many time, a long time. Have you met any lawyer who has told you that I have, for the bench, I am speaking for myself, that I have stopped any counsel from giving a citation, from making any submission? Have you come across any one gentleman? I'm using the word gentleman. I'm not using the another word. Find a gentleman lawyer who says that I have stopped them from making submissions. Show me one. If you don't know the court conduct, don't push us to a corner. Next.
Yes. Mass obligation.
Upgraded item 34.
May I appeal, Lordship?
Yes, Mr. Ahmed.
A petitioner arrested on 2/9/2024.
2/9.
Yes. LCR discipline.
On merit, you don't seem to have a case.
I have a case, Miller.
You see your written statement, nothing is introduced.
Not only written well. He has proved the linkage, Miller. He has
No,
proved the
but
certificate.
without saying in the written statement whose son or daughter you are, how will you prove the linkage?
That what a Miller. I am.
You see, every day I repeat this same story in the court. You see, a formal, no, it's still a formality, yes.
In the written statement, he has stated everything, Miller. Father's name, mother's name, voter list, school certificate.
You see, one of the president designate of one of the countries has a property in Calcutta. You are aware of it. I'm telling it every day. A president designate of a country owns a property in Calcutta. Now in India, we get the land documents by mere asking. If I apply in the portal, I get a certified copy of Jamavadi. Correct. So supposing A obtains that property of that document, my question is very simple. Will it make him the son of a president designate of a country? If you
Ye-
don't plead it in your written statement,
A written
you're,
statement.
you're not complying with the directions contained in Muslim Mandal as well as Sarwar and Sonwar.
Here is a in the written
How-
statement.
How you link it? You say nothing there. Let us see your evidence on affidavit. Which page?
Yes. PS 47.
47.
7. In this case, father reduced evidence.
Where is that evidence?
PS 52.
52. Was he cross-examined?
Uh,
We're more interested in cross-examination.
that part, Milord, I could not annex Milord, but in the LCR Milord, there may be.
This page which I have flagged is also interesting reading for you. Putting up two flags. Do we admit this, give the petitioner bail or take it up for hearing, or we can allow the writ petition right now? Down below order. And then the second flag. You've been able to follow, I think. Or we give bail and then we hear later on. Okay. Heard, Mr. This will be the IA. Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Ms. LDV, learned CEC appearing for respondent number 1. Mr. J. Pang, learned standing counsel for the FT matters, representing respondent number 2 and 4. And Mr. R. Talukdar, learned government advocate appearing for respondent number 3. And Ms. S. T. Khan, learned counsel appearing on behalf of Mr. A. Ali. Also, Ms. P. Barwa, standing counsel for respondent number 5. There's no representation from respondent number 6. Next para. The here it will be applicant, is IA. The applicant, who is the petitioner in the connected WPC 4967 or 2024, has prayed for releasing him on bail from the detention camp at, sorry, it will be transit camp at Matia Gwalpara. On his being apprehended and detained since 2/9/2024 in connection with opinion dated page number 74. This will be a writ petition, page 74. Opinion dated 31/10/2019, passed by so and so and so and so. Comma, whereby the applicant was declared to be a foreigner of post 25/3/1971 stream Next, the learned counsel for the applicant has submitted that he has documents to show that the applicant has documents to show that his father and grandfather were bona fide citizens of his projected father and grandfather were citizens of India, and his other sufficient documents to link himself to his projected father and grandfather. He is also submitted that the petitioner is the sole breadwinner for the family and has paid for bail. Next paragraph. The prayer for bail is opposed by the learned standing counsel for the FT matters on the ground that the opinion of the tribunal was rendered on 31/10/2019, and since then the applicant could not be apprehended as he was avoiding any detection thereafter. And it is submitted that in the event the applicant is granted bail, it's every likelihood that the applicant would abscond. Next paragraph. Having noted that the applicant was apprehended on 2/9/2024 and has suffered more than 2 months in custody, the court is inclined to grant bail to the petitioner on the following conditions. The 3-4 paragraphs right from there for bail. Bail of rupees 5,000 with one surety of like amount to the satisfaction of the Superintendent of Police within bracket Bolpeta. There will be a condition that after within 3 days from the receipt of the certified copy of the order and in compliance with the directions of bail, the authority shall take steps for releasing the petitioner from detention center, transit camp at Matia Kualpara. Next, as a condition for bail, it is provided that the petitioner shall not leave the territorial jurisdiction of the Superintendent of Police, Border Borpeta, without prior written intimation. Next, any violation of the conditions of bail would entitle the Superintendent of Police within bracket Border Borpeta to move this court for recalling of the order of bail. Recalling of the cancellation of the order of bail. Next, application stands allowed and disposed of. Border. SP Border. Borpeta. And the repetition you write, represented as the records of tribunal has been received. List the matter in the admission column. After 4 weeks.
Oblige. Oblige.
For admission, item 17.
Yes, Mr. Ahmed.
Please, Lords. My lords, while arguing this type of case, Lordship, heart beats high, heart very high, Lordship. My lord, my lord, heart beats high, Lordship. My lord, while arguing this type of cases, Lordship, heart beats high. Because I am in doubt whether uh, all the queries of the Honorable Court
You'll be
can
able to
be
satisfy.
properly answered or not, Lordship.
So you
Because,
want
my
to do
lord,
it you
in
want to
some
do it some
cases,
other day.
in
You want to do it some other day.
no, Lordship, today I am ready, Lordship. Because in some cases, Lordship, the advocates like me, Lordship. My Lord, draft the WS evidence, Lordship. You, Lordship, also will find in this case also, Lordship.
No, that would happen only on one case. If you are, if I can say so, I don't know. If you don't revise it, but if you are in a hurry to go to bank and spend the money you have received from the clients,
Lordship, that
then
is
perhaps you would not have time to read it again. Then these things happen.
yes, Lordship. Why?
But if you
is why
stop the habit of going to bank and doing expenditure, perhaps you'll have time to check all these things.
in this case, my lord, the father of the my lord procedure was examined, Lordship.
Where is your written statement?
Written statement is, Lordship, at page 46.
Because your certificate has no value, it has the state emblem. So
Lordship,
that goes,
yes,
then you have,
it is there, Lordship.
then you have only a Jamabandi.
Sarkari Gaubura. Zawabandi is, my lord, that is authenticated, yeah, my lord, those public documents, Lordship. In the Zawabandi, my lord, the linkage of the petitioner's father with his grandfather, Lordship, it is clear, Lordship. That is kindly see,
Where is your written statement first?
yes. There's 46, Lordship. Starts from base 45, Lordship. 46, yes. Annexure 11, Lordship.
Yeah, cool. Like, so how did I do this? I will do this stuff.
Exhibit A,
The exhibit is the 66, my lord.
page,
My lord, that is at page 25, lordship. My lord, Khandu Sheikh, here is my lord, there is a spelling mistake. D is my lord missing, lordship. Son of Asu Sheikh, lordship. Asu is there, lordship.
actually the difficulty is that in the written statement, these things are not there.
Lordship, that is, we have lordship. Now, petitioners, two paternal uncles. My lord, Abdul Quddus, Abdul Majid. Abdul Majid is the PW, OPW2 in this case, lordship.
After 65, what is the next one? 1970.
After 70, lordship. 70, the petitioner's father is there, lordship. The petitioner's father, there is a
Jabbar.
spelling mistake. Khanu Sheikh, Khalu, L is there, lordship. Khalu Sheikh. Wife of the petitioner's paternal uncle, Abdul Majid, OPW2, is there, Anwara. Hazira Khatun is the petitioner's mother. And Moimon Nessa is grandmother, lordship. House number same, lordship, 19.
What is the linkage?
My lord, linkage of the petitioner, lordship.
Hmm?
Linkage of the petitioner, lordship, school certificate is there, that was not exhibited, lordship. Now, his father was examined, lordship. Father examined, lordship, he stated, leading evidence that the proceedings, his father, his son.
Abdul Jabbar.
Abdul Jabbar, lordship.
Where is his evidence?
Evidence is not enough, lordship. The In the cross-examination, lordship, it is clearly stated, lordship. OPW3 lordship. Yeah, it is in vernacular, lordship. Five sons, my lord, names of five sons have been stated.
You have submitted a translated copy of the cross-examination of DW3?
Not for submitted, lordship. Not submitted, lordship. I will first submit, lordship. I may be allowed to translate, lordship.
All sides are represented. Depository matter could not be taken up today. List again in the next week. Mr. Pang, go through the records. We'll need your assistance here.
3/2022.
We have held that in light of the discussions above, the petitioner is not found entitled to any relief. However, we have made a further observation. In this case, we note that the petitioner has joined service pursuant to order dated 1/4/1996. Thus, the petitioner has stagnated in the post of electrician for about 28 years. It is well settled that when there is no statutory rules holding the field, the government has the power to issue administrative instructions, which would go to ensure that the petitioner and others similarly situated like her do not suffer any injustice by way of stagnation in her career. Therefore, before parting with the records, this court is inclined to observe that in view of the cases discussed above, it will not be open to the court to issue any directions to the government. However, the government is not only expected to be a model employer, but the government is committed to bring about a welfare state. And as such, it is hoped that the appropriate government would make an endeavor to take an administrative decision at the highest level of administration in respect of the grievances of the petitioner by taking note that the Assam Technician Establishment Service Rules 2015 for the Assam Public Works Department has not yet been notified. However, the observations in this paragraph shall not be construed as a direction of the court. There is some typography error which is noticed later on. So you can see it, but it will be released tomorrow. There are some corrections.
Item 8, BA 2732/24.
In this, we have formulated 3 points. Number 1, delay in conclusion of trial. Rigors of section 37. Third is non-submission of FSL or chemical examiner's report. We have answered all these 3. And the application for bail is rejected. The
I'd like to mention for item number 5 and 6 that LLS or let's say the limit standing on of the 4% department Mr. P. is sick leave. His health condition is not well, your lordship, so he cannot appear today. So lordship kindly adjourn the matter for that.
This has to be brought to a logical conclusion. We've been, with his health condition, we are adjourning it, but make sure that something happens in the matter. We take it up next week. Okay, both sides are represented. It is submitted that it is submitted on behalf of Mr. V. Rajkua, standing counsel for the Corporation Department that is unwell. First off, for the said reason, the matter is reluctantly allowed. The prayer is reluctantly allowed. Matters is adjourned today, placed in the next week on a date to be fixed by the registry. Okay.
Daily list item 1.
Please, your lordship, can matter may pass over for the time being?
Time being.
Yes, your lordship.
Okay. Yes.
Item 2.
Senior counsel is on next. 22. Pass over for the time being.
This is the only matter. Request him to be here fast.
Grant some time. Starting with pass over.
It's okay, but we don't have any other matter. Correct. We'll wait for some time, but ask him to be here.
This is a special bench now. In fact, we informed also, man.
But it's okay. If
No,
he's on
but
legs,
he's a
he can't
spec-
help it.
No, he was in different bus.
It's okay. We are waiting for it. But it's okay. We are waiting, but we can't. We are waiting for him. He's asking to come.
Building matter 9. One item. One item.
Right. Item 1.
That was smart. My lord, for convenience.
Just a minute. Mr. Goswami. I would like to have a word with Mr. Khan. There are some issues which are coming up. I'll ask him to be here in my chambers. After the court hours. He's going to be there. Yes.
Yes, my lord, for our convenience, my lord, I have to prepare the my lord short written argument, my lord. I would like to place this.
Just a moment. Why it has come to this bench?
Because my lord, the co-accused petitioner's bail application is disposed of by your lordship, my lord.
Where is that order?
Order, my lord, this is. This is my. Page number 104, my lord.
1120 item 37 W section is
Yes. Okay.
So, my lord, I have prepared a short written argument, my lord, and placed it, my lord.
Yes.
Yes, my lord. In this case, my lord, the petitioner was arrested on 26/10/2022
He has been in custody since 2 years, 26 days. Out of 8 accused
Where
persons,
where is the FIR?
FIR, my lord, page 16.
He is the driver of Innova car.
He is the driver of the
Then-
car and also owner of the Innova.
Then
And my lord, two,
it is seized from his conscious position.
my lord, 2 cars have been seized. And the contraband was recovered from 2 cars. And one of the driver and owner of the one of the car have been released on bail. And I am the driver and owner of the another car. And I have been in jail. my lord.
In bail parity would not apply.
This is right, my lord. But kindly see, my lord, out of 8 accused persons.
How much, what is the quantity of drugs seized from you? It's a commercial quantity.
It's a commercial quantity. my lord. It's a commercial quantity. 619. Commercial
Where
quantity.
is the order granting bail?
Yes, my lord. The accused number 1, Shahjahan Ahmed Borwaya, who was granted bail by the trial court by order dated 3/2/2020.
Page.
Page, my lord, it is in the order sheet. However, my lord, I have collected the certified copy at this moment.
What is the date of the order?
Order dated 3/2/2024. In my written argument, my lord, I have clarified the written.
3/2/2024.
Or yes, my lord.
There's no date of 3/2/2024.
This is the 3/2/2024 is passed by the trial court, my lord.
3/2.
3/2. It's a trial court's order, my lord.
Oh, achha.
And owner is the Dhruvajyoti Das, accused number 6, who was discharged, my lord, by order dated 10/6/2023.
How many witnesses have been examined so far
7 were examined,
out of?
16, my lord.
You were driving which car?
Innova car.
Innova car.
Yes, ma'am. I am saying that the person who is in the my lord, front seat of the vehicle, he Sabir Ali, he is the owner of that materials.
And The heroin seized is how much?
Is my lord 690 grams. 690.13 grams.
690.13
13 grams. And from another vehicle, my lord,
This,
573 grams.
Mr. Goswami, you please see this. Just find out the, whether the FSL is there. Then give it to him. FSL is tested positive. FSL is tested positive. Chemical examination report is positive.
Yes, ma'am. This is a fact that it is a commercial quantity.
No.
Yes, ma'am.
Is it positive?
FSL, my lord, I have not found the FSL.
Okay.
FSL is not supplied to me.
Okay.
And my lord, another from another vehicle, 573.11 grams were seized.
Yes.
2 vehicles were seized. And in my vehicle, my lord, another person severely. Who is the culprit, my lord? I am saying that. I was hired by the severely. I also stated that nothing materials recovered from my body. It is from the car.
Yes.
My lord, that my lord, I'm saying, my lord, out of 8 accused person, 5 were granted bail and discharged. And I am saying that I am not the owner and I am not connected with the materials which is recovered from the vehicle. It is the person, the passenger who my lord loaded and who my lord done this act, my lord, Sabir Ali. I also stated in his cross-examination also, my lord, nothing recovered from me, from my body position. And on the same footing, my lord, the another vehicle's owner and the driver, both were granted bail, where also the commercial quantity was recovered. And if your lordship might go through the cross examinations of the my lord examined witnesses, there on perusal of their my lord depositions, the conviction cannot be done, my lord, against me. It is a clear case of acquittal. Means, my lord, more than 2 years have been in custody.
Yes. That's all.
Yes, my lord,
You're relying on me?
whatever, my lord, I have money, my lord, my ground and everything, my lord, I have written in my petition, also with my written argument, my lord. These
Okay,
are the grounds I have taken, my lord, for bail.
okay. Any cases you are relying on?
Yes, my lord. This, I would like to place this judgment. I am
Yes,
relying on total my 7 citations. Yes,
you
I'm
made a
sub-
compilation?
Yes, but I am submitting. Yes.
This person is accused number?
This person, my lord, he is, my lord, accused number 4.
Accused number 4.
He is accused number 3, my lord.
Accused number 3. This will need one more thing, the seizure memo.
Seizure memo.
Is it next in this petition?
Yes, I have annexed.
Where is that? Which page?
This is total. This is the first one, page
Page?
22. Page 22, man. I have, this is the type copy of the original one.
Where is the charge sheet?
Translate, my lord. This is page 38, my lord.
8. Okay.
Since last 2 years, 25 days, my lord.
10 years extendable to 20 years. 5 rupees, 2 lakh.
They have been discharged, my lord, at the time of framing charges. That was also the owner of that car.
If somebody has got discharged, it is because of goodness in the Assam police. Still not learned how to comply with the various provisions of seizure, sampling. Yes, Mr. Goswami, what do you say? These citations you are given for which reasons?
My lord,
And give the paragraphs also. That's
okay,
give the paragraphs.
my lord.
Yes. Just a moment. The citations are which? On what point? The case citations are on what point?
Third citation, my lord, out of 7, 5 so are in delay ground. And 21, the article 21 is prevail over 37 of NDPS Act. And 2 were, my lord, this is some Rajasthan High Court passed judgment in that way. So, my lord, delay ground, I have filed citations, my lord.
Just a moment, then we'll have to look into it. Yes, in the meantime, you can make your submissions.
Because commercial conspiracy, the transporting containment drugs for trade, huge amount of drugs that seized from the vehicle. So at this stage of trial, I'm opening the something deal.
You have not applied for cancellation of bail for others. Yes, Mr. Chaudhary, what is the date of your arrest?
My date of arrest 26/10/2022
26/10/22 and remand order
and remand order my
same day.
since then, same day, same day.
Yes, Mr. Goswami, apart from commercial quantity, what else?
Out of 16, 8 were examined, out of 16 PW, 8 were examined. So let's say, around this maybe examined only
8.
careful. Last date was 3/9/24. That's it. So what is it? And then because we have done major examination.
Yes, that's all. Okay, we can examine the Israeli pass orders. Uh, Heard the submissions of Mr. H.R. Chaudhary, Land Counsel for the petitioner, as well as Mr. D. Goswami, and APP for the state. As the scanned copy of the case records is voluminous, some time would be required to peruse the same. Stop. List the matter for delivery of orders in the week commencing 25/11/2024 on the date to be fixed by the registry. Fixing it actually for delivery of orders, this will take some time to read.
25, my lord, 25 minutes.
Yes.
My lord, your lordship, the next week I have some difficulties, maybe the 3rd of December, my lord.
No, it's for delivery of orders.
Okay,
It's for delivery of orders.
my lord,
Will not be hearing you, but
My lord.
this is the records. I have to go through it.
my lord,
It is both pages.
my lord.
Submission with DP Goswami. Also had. But, tell Mr. Fugan to meet me after the quotas. Yes, Adori.
Timing item 2.
No, it's okay. Yes.
Out of this, only one DOB is the owner of that company. And these two are acting as an agent of that company. I have received a respectful submission as part of their submission that it is a cooperative society. According to them, it is a cooperative society. And therefore, we is not applicable. I mean, one side is not applicable in this case. May I take a lot of one society. NGO. Now the question is whether NGO can collect money from outside.
No, just a moment. You are saying this Anirban Deori, who is the
Is the owner
owner of?
Fortune. Bulls.
Hmm?
Bulls eyes. Bulls eyes.
Okay. Yes.
So what is
If he is the owner, how can it be a cooperative society?
may I take the lordship to pen your objection, lordship? You file an objection to the Anirban. Oh, lordship, page 20.
Yes. Your reply, which page?
Page 20, lordship.
20.
Lordship, para 4.
Yes.
During the preliminary inquiry, it was found that Kaiser Fukan and Anirban Devi are the primary responsible for regulating and managing the entire syndicate and are involved in making false promises to individuals, assuring them of high returns on their money with interest. It has also been found that Bullseye Company is a private entity and it is not registered as a needy group, a needy company or under the government of Assam, nor as a self-help group or a credit cooperative society. Under the direction of Kaiser Fukan and Anirban Devi, several agents including Vishal Tamuri, Pallab Bodole, Mohit Dakarat, Didas Kachapnath and Jyotishman Mahanta has been involved in making false promises to the individual. So from this lordship paragraph, it reveals that it is not registered either it's as a company, neither as a self-help group, nor as a cooperative society. It is not a registered in any way. Then lordship clarify the preliminary inquiry further reveals that Bullseye Company has violated banking regulation. It was neither registered under Reserve Bank of India nor the Security or Exchange Board of India. Furthermore, they have been misleading the people with fraudulent advertisement claiming affiliation with various public and private limited companies to deceive innocent people. Based on the finding of the preliminary, it was observed that the company is not a registered with any regulatory agency. It offers unusually high interest rates as for return to rural gullible customers. Investors are unaware of their
where their money is being invested, there is a high risk of losing the principal amount or expected return. There is no protection or recourse for investors in this case of default. Also, therefore, cognizable offense has been registered. Here also mechanism para 9 that during instant case, notice under section 35(3) of the BNS was issued to Anirban Devi by the investigating officer of so and so. But Anirban Devi did not appear before I and is responding till date. Because notice that so and so has been also issued to Assam Police in this regard. The investigating officer of Naga PS also sees some incriminating documents from the residence of Anirban Devi. On 11/9/2024, one has check bearing number so and so, account number so and so, holder namely Nikhil Jyoti Bonia, amount of rupees 8 lakhs and pay to depositor Anirban Devi on was also seized from the residential demand of Anirban Devi during her search, house search. That the investigating officer of Nagaon has also collected bank statement of the Anirban Devi, which is also revealed that the banking transaction was rupees 4,66,80,597, which score of multiple depositors to 12 with effect from 1/4/24 to 29/24. So, Lordship, from the preliminary investigation, it's revealed that they are neither a company nor a NGO, nothing. It was not a registered. Whether they are entitled to collect money from the public or not, that has to be revealed. They are saying that they are NGO. Whether NGO, be it NGO, be it a cooperative society, that has to be registered. And why BARSEC under section 22, what BARSEC says, who is a depository, that has been defined under section 3 also. Where take your Lordship to kindly the BARSEC.
Let me take a very horrible example. You have two friends here, Ms. Begum and Mr. Goswami are there. Now, they come to the bar every morning, and then she pays, say, 10,000 rupees to Mr. Goswami before all your friends and says that here your yesterday's fees. Correct. And in the evening, Mr. Goswami comes to Ms. Begum and again gives that 10,000 rupees, says that now today's fees I have got, you take your share, 10,000 rupees. So every day they do that. There are many people in the table. There are many people in the table who get excited that how these people are getting every day 10,000. Correct? But at the end of the day, she takes back 5,000, Mr. Goswami takes back 5,000. And again, next day morning, they come back, pull up 10,000, and then every day they tease you. Now, is it a transaction? That is the example I am giving. Now you say that there's a transaction in the account. Well, there is a transaction, no doubt about it. Whether this transaction is a deposit, that's number one. Number two, whether there are some persons who have made the deposit. Somebody must come and say that, yes, I am the client of Ms. Begum and I have paid 10,000. So have you been able to connect it? Otherwise, transactions are transactions.
From that point, Lordship, I have inquired the IO. And today, he has just sent me a mail, Lordship. I'll read the mail, Lordship. This Lordship is seeking time, as because investigation is in the nascent stage. Initially, it has been investigated by Assam Police, Lordship, and subsequently, Lordship, it has been entrusted to CBI, Lordship. And CBI, Lordship, is now scrutinizing all the documents, Lordship. In that regard, all the transaction has been done by UPI, Lordship. It's not a cash deposit, Lordship. It is to UPI. It is to UPI. Therefore, the State Bank or whatever that might be.
No, you see, Mr. Alo, there's only another point. You're missing that out. Now, everybody in the state knows about this, firm or company, whatever it is. And they all know that the police is after them. Now, assuming that somebody has lost even 10 rupees, will he not come and then now file an FIR saying that I am one of the persons who have deposited 10 rupees out of the false promise, and now this office is closed. So there must be some person at least.
Many things comes out like this. There are persons who are depositing illegal money also. They will not come out. And the depositor who are legally depositing their money, they may also under the apprehension that something will happen, they will also not come out.
Okay.
That is the situation. So therefore, at this stage, and because it's an anticipatory bill lordship, CBI will investigating recently lordship. And the IO lordship, where he wrote me a mail lordship, may I read lordship? May I read the mail? This is to inform you that the CBI ACB Guwahati RC customer has been registered at CBI Guwahati on 23rd 10/2024, 23/10/24, it has been registered. Arising out of Nova PSS number 859/24 dated 3/9/24. And the case diary along with the other connected documents were received by the undersigned on 26/10/24.
It is registered on 23.
Yes, case was registered on 23/10 by CBI. Re-registered. The renumbering. And the case that along with the other connected document we received by the undersigned, that is the IO, on 26/10/24. The scrutiny of the documents are being done. During CBI investigation, correspondence have been made with the SBI, Noga, Axis Bank, Noga, Punjab National Bank, Seba Kolkata, ROC Guwahati, RBI Guwahati, IRDI Hyderabad, the registers of society, Assam, and with other government department. The replies are awaiting. So replies to that effect is still awaiting, lordship, with respect to the cases. Further, I was on the tour to Kolkata with effect on 12/11/24 in connection with CBI ACB Shillong case number so chit fund case of Tripura, which has been registered by me, where I fall sick on 13/11/24 medical report enclosed. On 15/11/24 evening, I returned back to Shillong and went for medical checkup at CGSH on 16/11/24, where the medical officer opined that I am suffering from acute pharyngitis with fever and weakness, as advised in 7 days medical rest. Also, CBI case number so-and-so, Anirban Besuri have been registered at CBI on 26/10 so-and-so, arising out of so-and-so. And Hojai PS number dated so-and-so has also been investigated by me. Inside, therefore, request to kindly ask for another 2-week adjournment of the honorable court. That is the prayer of the IO. So all forward losses on 26/10 only, the case diary has been received by the IO. And lordship, we made all this effort to detect, lordship, we wrote to the SBI, we wrote to Axis Bank, we wrote to lordship the National Bank, even lordship the ROC Shillong lordship. But their replies are awaited, lordship. That is why, lordship, we could not at this stage, lordship, certain whether the depositors, whether the account shows huge amount of money collected, lordship, could not be found out, lordship. Therefore, I'm praying, lordship, at least give us some time to find out who are the depositors and whether they are agreed with the deposit. Understand, they have taken, lordship, it's a NGO, they have not collected, lordship, any money, lordship. It's completely, even lordship sees the act, they cannot take loan from a private person. It is not a question of 5,000 to 10,000 lordship. Had it been a very small amount, the matter would be different, lordship. Crores of rupees has been collected by this company, the so-called company, lordship, which is not registered, lordship.
What is the name of the act?
It's a banning of banning of unregulated deposit tax. Banning of unregulated deposit tax.
This is a state legislation.
Yes, lordship. It's a central legislation.
Banning of unregulated deposit scheme, 2019.
2019. Lordship. Lordship, I kindly see definition part. Definition part. Deposit, lordship. What is deposit? This has been defined under section 4. Deposit, may I read, lordship?
Yes.
Deposit means an amount of money received by way of an advance or loan or in any other form by any deposit taker with a promise to return whether after a specified period or otherwise, either in cash or in time or in the form of specified service with or without any benefit in the form of interest, bonus, profit, or in another form by does not include amount. These are the criteria. Does not include amount received by cooperative society, scheduled bank or a cooperative society, or any other bank company or defined under section 5 of the banking regulation. So these are the restrictions. It has been shown that cannot be regarded as a deposit process. Deposit, finally, Lordship, what is unregulated deposit, Lordship? Your Lordship will find that in section 14 and section 70, not clause 14 and clause 17 of the Act. Clause 14. Clause 14 mechanism.
This is clause 14 of which section?
Same definition part, Lordship. Definition part, section 2, definition part, clause 14. There is a Lordship schedule meant in the Act, which says that these are the regulated deposit schemes. Regulated, may I read, Lordship?
Yes.
Regulated deposit scheme means the scheme specified under column 3 of the first schedule. There is a schedule appended in the Act, Lordship, which mention about the regulated deposit schemes, Lordship. So whether their company falls under this regulated deposit scheme, Lordship. There is no mention about NGO. If they are saying that it's an NGO, there is no message. There is no mention about the NGO. The only cooperative society is there. But even then, if your Lordship says that it is, they are saying that it's a cooperative society. Again, then cooperative society actually left.
But what is the charging section? How much is the punishment?
Punishment, Lordship, is it depends, Lordship. Section 21 is different, Lordship.
21.
Yes. Section 21 punishment for contravention. Section 3. May, if your Lordship says 21(3), it may extend to 10 years. Any deposit taker who accepts deposit in contravention of section 3 and fraudulently defrauds in repayment of the deposit or in rendering any specified service shall be punished with imprisonment for a term which shall not less than 3 years, but which may extend to 10 years. So it will extend to 10 years with fine of 5 lakh rupees.
Okay.
So Lordship, if your Lordship has gone through the CD, Lordship. And
We have to give it. I won't remember.
Lordship, I'll give you the CD, Lordship. But what we are submitting, Lordship may kindly give us some time, Lordship, so that we can collect some more material against this accused person.
Let me examine the
Yes.
case date. You will see.
They are saying, Lordship, it is a bullseye, but money is collected in the name of some other bullseye, something another name, with a banner that they have displayed a banner with some scheme. They are, and these other two accused persons, they are helping the main accused, Lordship, in collecting money. There is a transaction, Lordship, from one bank to bank of the accused, Lordship, Anirban Deori. Money has been transferred to the other two accused persons. 10 lakhs rupees in one day. Again, another on 1/7/2024, on two occasions, on 1/7/2024, 20 lakhs rupees has been transferred from the account of Anirban Deori to this accused person.
Yeah, go through it. You have anything more to say? No.
No, Lordship already seen, my lord, that the dates, my lord. He is insisting that they did not get the time to investigate, my lord. Because the FIR, my lord, it was initially lodged on 3/9 and Lordship.
Just a moment.
Yes. By Assam Police, my lord.
Yes.
The 3/9, my lord, was the FIR, my lord. Thereafter, Lordship granted bail on 8/10/2024, my lord, to the other, who is also named, my lord, Kashyap, my lord. So from 8
Bail
10
on which
8
date?
10 2024, my lord.
Hmm?
8 10
8/10.
2024, my lord. That was around 35 days of investigation by the Assam Police, my lord. Thereafter, now, my lord, from 8/10 today, my lord, it's my lord. No, 8/10 no, more than a month, my lord, around more than 43 days possibly, my lord. And they investigate. They started investigation, my lord, registered the case on 23/10, my lord, around 29 days now. And the objection itself, my lord, last occasion, my lord, we have shown before lordship, my lord, that, my lord, yet to be ascertained, details are awaited, further times required, my lord. And the objection also, my lord, that they might flee or influence, my lord, and, my lord, they may conceal, intimate, and they may go for, my lord. So, my lord, that earlier order which was passed by your lordship, my lord, that is ample clear that if they find something, my lord, they can go for cancellation and everything. That is already there by your lordship, my lord. And this act, one section, my lord, possibly, my lord, others also always seen, my lord, here, my lord, regarding, my lord, section 32, my lord, 32(1), my lord, section 32(1) of the, my lord, this Baths Act, my lord. That
Yes.
here, lordship, find out that designated court may take cognizance of offences under this act without the accused being committed to it for trial. So whether, my lord, arrest, detention, and those are required. And the primary, my lord, whether if any depositor has come, my lord, to say that they have been defrauded, high returns were, my lord, solicited by the petitioners, my lord. All that, but and strict conditions, my lord, lordship may impose, my lord. And they are local men, my lord, they will definitely cooperate with the investigation.
Lordship, reply, Lordship. This case is not only registered under draft set, Lordship, along with guard set or ICC offences are also there. Lordship.
Which are the offences?
Offense, Lordship, 3162, 300 cheating and criminal breach of contract. They are Lordship.
Lordship, just see who they have cheated, my lord. That is good for us, my lord.
3162.
3162 and Lordship.
3162 is cheating.
3162 is criminal breach of trust.
Criminal breach of trust.
18 to cheating.
406 ITC. And
Seven.
3184
Seven.
that is
Seven.
cheating.
3184.
3184
31
within bracket 4A.
31 4A.
8 within bracket 4.
3184.
DNS. That is cheating. 402 policy.
This is 420.
Lordships.
61 61 is 61. One page. 61 2. 61 1 bracket 2. That is criminal conspiracy. 1 page.
This is 120B.
Yes.
And lordship's query, my lord, one question lordship put to him, my lord, that whether some depositor has came or not, my lord. In other cases also, we tried to convince the court on that count. In one case, my lord, because When there is a genuine concern, my lord, the depositor would certainly come before the agency, Assam police, or whether it is CBI. my lord.
Let's see what the case
Yes,
diary
ma'am.
says.
Yes, ma'am. The objection only we will be relying on lordship, go through it.
Lordship, my humble prayer, Lordship, this case is deferred, Lordship, for 2 weeks. We have started with the-
We'll see that.
That's my submission, Lordship, that we can-
We'll record that.
My colleague wanted to say something.
Lordship, I'm appearing for item number 3 and 4. So I want to rely on the submissions as submitted from my learned colleague. Only thing is I want to add is that on last occasion, Lordship had taken a view regarding consideration of the interim. These petitioners now they are completely aloof. They are out of their families' reach. Maybe they need some good counseling. They need to come down. If they have got anything to say before the IO, they will come and they will say. If they have any documents, they will also produce. Only thing is that they need some protection because 77 days have passed now since they are away from their family. These 4 petitioners I am appearing for. These 4 petitioners they come from not well-to-do families. They are absolutely youngsters, unemployed youths just before they have registered into this cooperative society that is known as the Bullseye Foundation. They were carrying out some societal works, and at the same time, if some sort of allegations have come up, they need to be answered and they need to be brought into the custody of the investigation so that they can answer because they are the people they can give the proper answers. So it is my humble prayer that the interim may be considered at this stage and let CBI come they conduct their investigation, further investigation, so that and they will come and cooperate and with the stringent of conditions, and if anything is found then their interim can be cancelled. My that is my submission on part of the 4 petitioners. Item number 12.
Lordship, in reply, Lordship, notice has been served upon them to appear, Lordship. They did not, Lordship. Opportunity has been given to them to appear by the IO. But they failed to do so. Rather, they absconded. Why they absconded, Lordship?
Lordship,
There is
just
nothing
for
illegal. They are on the poor and downtrodden people. They are helping.
absolutely
Lordship,
correct, absolutely
they are
correct.
violating the provisions of law, Lordship.
Lordship.
They are entitled for any interim duty, Lordship.
Lordship, and it was served to them on 5/9, only 2 days after lodging of the FI. They were not in a position because of the pressure that was happening around the media, everything, this trading scam, the Sumi Bora case, everyone now. So big people. These are youngsters. They just had got like no. They are scared. What has happened? And because of a lot of advices were coming from other people that see this thing is that you people are carrying on some good works. Now your name has been because this affair has been lodged by the IO, not by any private investor or by any private person, from the police. So police have started the pressure on them because of the fact that police is also finding it the pressure from the top brass. So this is a secret.
It's okay. it's
Yes, my
beyond
lord,
the
that
point.
is my humble. Interim may be
There
considered.
is no bar nodding by FI.
There is-
Yeah. No, regarding the
There is no
35.
bar.
Possibly the
things-
notice from very CBI.
We have not received any notice from CBI, from the
CBI.
state police only. On
Whatever, you have received the notice.
yes.
Got the opportunity to appear before the IO. You
Ap-
didn't.
we want to
That's
appear.
okay. You don't have to interact with each other. You are addressing the court, not to each other.
That is my humble prayer, your
If
lordship.
you want to contradict him, there's a coffee house down below. Have a full-length debate.
Outside we do Lordship discuss about case.
Yes.
He is having a lot of trouble, my lord, nowadays. We will several cases, my lord.
Discuss cases of-
Hmm?
He is having a lot of trouble. We will say all over this Bad's case, my lord. So
Yeah.
he has to appear for the CBI. Difficulty on he is alone, my lord.
Okay. Yes, and then yes. Night, Silo. Record to Silo. Chamber. Just give the names, he'll record it.
Yes, my
His face.
lordship.